As a middle schooler, my client smeared deodorant on his teacher's laptop, desk, chairs, and the floor of her classroom, and the state prosecuted him for the crime of culpable negligence.
When we describe negligence, though, we're typically describing a state of mind, right?
Take a listen to this moment from inside the courtroom. A defense attorney argues that the student's actions were misunderstood, saying his client simply created a blueprint on the teacher's laptop. But the prosecutor says that situation looks far more serious. The question now is whether this is just poorly judged project or something the authorities had to treat as a potential threat. Here's the exchange inside the hearing.
As a middle schooler, my client smeared deodorant on his teacher's laptop, desk, chairs, and the floor of her classroom, and the state prosecuted him for the crime of culpable negligence. In Green, this court made clear that this crime requires proof of reckless indifference or grossly careless disregard for the safety of others. But the district courts of appeal are split on how to hold prosecutors to this standard. The first and second districts hold that this crime requires proof that the defendant knew or should have known that his conduct created a likelihood of death or great bodily harm. But the third district in this case rejected that standard and held that my client's conduct rose to the level of criminal culpable negligence. I'm here to ask the court to affirm the standard or approve the standard from the first and second districts in Kish and Azima and reverse the third district's decision in this case. Kish and Azima got it right, because their standard is clear and prevents absurd and unconstitutional outcomes. Their standard clearly explains what level of negligence is sufficiently wanton, reckless, and egregious to rise to the level of a crime.
When we describe negligence, though, we're typically describing a state of mind, right?
We're describing
a heedlessness of risk.
Yes, the failure to show the ordinary duty of care.
Okay, can we establish whether we are, when we discuss culpable negligence as opposed to other types of negligence, we are necessarily also speaking to the eventuality itself, that is the risk of what? The type of harm. Because it would seem to me that the rule you're proposing sort of freights the idea of negligence with not just a heedlessness of risk or a disregard of a substantial likelihood of harm, but also it speaks to the nature of the harm. And I wonder if you can direct us to support for that position, either in the statutes or in the cases.
Yes. So in Green, this court explained that culpable negligence is an act or omission that creates an unreasonably great risk of harm to others. So the risk of harm to others is built into the standard. It's not just heedlessness of risk. It's not just
right. But I'm asking about the content of the harm. I'm talking about. I'm asking whether, in the definition of culpable negligence at common law, or under the statutes, the serious likelihood of serious bodily harm or death is baked into the state of mind itself.
Yes, I believe it is. It's not defined, the legislature hasn't defined culpable negligence, but the case law...
Can you direct us to the best support in the statute for your position?
The best support in the statute is... So turning to the text of the statute, my client was prosecuted under section 78405, subsection 1. The text of that subsection provides whoever, through culpable negligence, exposes another person to personal injury commits a misdemeanor of the second degree. Notably, the legislature made a purposeful textual choice to require both culpable negligence and exposing another to personal.
All it says there is to personal injury, right? It doesn't say grave personal injury. It doesn't say serious bodily harm or death. The context in which you've just articulated the type of negligence seems possibly to me to cabinet to personal injury. Like that's all that's all the risk had to be. That's all the possible harm had to be. Tell me why I'm wrong.
So, Your Honor, I think that's wrong because the legislature required both culpable negligence and exposure of another to personal injury. And when we look at Kish and Azima and compare the standard in the first and second DCAs with the standard in this case, the courts are required to interpret statutes in a way that avoids calling their constitutionality into doubt. And Kish and Azima do that. The third district's decision in this case does not. In this case, the third
constitutional issue, though, because I mean, we have strict liability crimes. I mean, so let's refocus you on, so the relevant language here, or at least the starting point, has to be getting our minds around what culpable negligence means, right?
Yes.
Negligence in general refers to the creation of an unreasonable risk. Okay?
Yes.
Right? The culpable part, I think, signals, and I think that what Green was getting at is that there's sort of an elevated, when they talk about, a great risk, it basically kind of increases the probability of the harm from just the, sort of the unreasonable risk to a great likelihood that whatever the risk is that you're worried about, in this case, personal injury, is going to occur.
That's exactly correct, Chief Justice.
To the extent, it seems like the court also, when they say that reckless indifference or grossly careless disregard means, it's possible that what it's talking about is that the quote-unquote mens rea, or the state of mind, is that unlike some negligence that can occur when there's just sort of careless behavior, you're driving and you reach over to grab something and you get an accident. In the recklessness context, the negligence, i.e. the creation of risk, has to be intentional. And I'm wondering if the way to kind of understand culpable negligence, the statute obviously signals to you that the harm that you're worried about exposing people to is personal injury. But if you focus on the culpable negligence thing, it seems like it's drawing your mind's attention to two things. One is whether you're creating the risk through intentional behavior as opposed to carelessness, i.e. culpable. And then the culpable negligence combined, the idea that the risk has to be greater than just the sort of the regular amount of risk. So if we turn to this, what evidence in the record was there that your client's action was intentional, or what, if any, evidence was there that he intentionally put the gel or whatever on the floor? Because obviously the floor is the only thing that relates to the potential of personal injury, right?
Yes. So the evidence in the record that he intentionally did that, there's no evidence that he intentionally caused that harm or sought to cause anybody to slip.
There's a difference between sort of wanting a specific result versus intentionally. You can be carrying a bucket of gel or whatever and drop it on the floor, and then how you react to that may be sort of negligent or not negligent. But I'm just wondering if there was any evidence that he had intentionally put the stuff on the floor.
So the teacher testified that she asked him, "Did you do this?" And he said yes. So that's the state's evidence in this case.
Okay. So then on the aspect of the how high the probability of personal injury was, what was the evidence on that?
The teacher testified that she thought that the deodorant created a safety risk in her classroom, and the officer, who was the state's only other witness, testified that if she walked over it, she thinks she would have slipped too.
Let me know what you think about this case. Was this an overreaction by the system or a situation that had to be taken seriously? Drop your thoughts in the comments. And if you want more courtroom moments like this, make sure you subscribe to Bench Breakdown.